as an owner, you know that potentially your property is at risk from criminal behavior, potentially from the outside and even more likely from the inside. Our second video in this series addresses crime prevention through environmental design. That's what you can do to help physically with a property. But this particular video focuses on the crime-free lease addendum and what you can do to ensure that those inside your property are not causing a problem, and if they are, giving you tools to get them out as quickly as possible. We also have other sessions on screening, and that will help to keep people from even getting to the leasing process and signing the application. But today, let's talk about the specifics of the crime-free lease addendum, which you can download at arpola.org. The fastest growing area of concern for many property owners is the area of drugs and crime on rental properties. Part of the reason that this is true is that many states and local areas have adopted ordinances that place the burden of keeping criminals and thus crime out of neighborhoods, and that burden's been placed on the rental owners in the communities. There are penalties, there are fines, up to and including jail time in some areas for the owner or manager of a rental property if they allow illegal activity to happen or continue to happen on their properties. There are statutes that have been included into landlord-tenant law in many of these areas that then allow for an expedited drug eviction. In other words, if you can prove illegal activity, especially if it's drug related on your property, then you're more likely to get whatever the fastest form of eviction is in that state. But how do you ensure that you don't have to deal with the costs that come with illegal activity on your property? It starts with a commitment to awareness and then action. So awareness means becoming a very involved manager, knowing what you're looking for, and then taking action on that. And one way to do that is to implement the crime prevention through environmental control checklist and then this lease addendum. This is a copy of the lease addendum, and although we know that no lease addendum or lease language can totally protect you, this document can go a long way to acting as a barrier to ongoing criminal activity in your property because, A, if you have someone sign this at the outset of the lease, they understand exactly how strongly you feel about illegal activity in the property, and the language in this lease addendum actually allows you to go for a more expedited eviction, even in areas that have not set that aside as a remedy. We'll talk about that when we get into some of the later clauses, but it automatically shows as a violation of their lease if they have any kind of criminal activity on the property, and that will allow you to at least go forward with an unconditional quit notice. So let's look at the key terms that we're going to address in the addendum. Some of the key terms: landlord, owner, manager, and staff all refers to basically the same entity. That is you and anyone acting on your behalf. So anytime that we use any of those four terms, we're talking about you or anyone else that helps to manage and control the property. We'll talk about resident and occupant, and specifically that means the people that are on the lease, the people that are listed on the lease, they've signed, or they have been listed as living in the house. Member of the household could mean someone under age 18 that is not listed on as a signer on the lease, but yet still lives in the household. There's guest, so someone who is a guest of the resident or a member of the household. Basically the same thing as a residence invitee. So those two terms are relatively the same. Or any person under residence control. So we try to make sure that we cover anyone who is on the property that has any relation to specifically the resident, and cover that in as many ways as we can. We also start with a disclosure and protection clause at the beginning of the addendum, because one of the things that you never want to do with a new resident is have them feel like you're guaranteeing safety and security for them. So we want them to know that, yes, we're going to, as an owner or manager, take every precaution, take every step that we possibly can to make this property safe and to eliminate criminal activity on the property. But there's only so many things that are humanly possible, and so we start with this disclosure. We say that the resident understands that crime can and does occur in every segment of life and in every community or neighborhood, regardless of the location. So you are not ensuring in any way that the community or the neighborhood is completely crime-free or that it will remain crime-free. That's just a part of life, and so you set that forth in the initial sentence of the agreement. You also say specifically that no property can or should be considered totally safe and free from crime, regardless of the measures taken to the contrary. So you want them to know that you're going to do the best you can, but no matter what you do, you can't consider that this will always be completely safe and free from crime, although you're going to take all steps possible. So we are saying very explicitly that you cannot warrant or guarantee the resident, the resident's occupants, their guests, their invitees, anybody, you can't guarantee their safety or security at, on, near, or off this specific property. So you're letting them know up front that there are no guarantees. You also say, resident understands that the safety of resident and resident's household is resident's responsibility and not the responsibility of the community or of the landlord, owner, manager, or staff. So in other words, you're going to do everything that you can, but they have to take some personal responsibility to keep themselves safe. However, you are going to ask some things of them to help you in your endeavor to keep the property safe. And the first thing that you're going to do is they themselves, nor anyone involved with them, they cannot engage in criminal activity. So, a resident and any member of the resident's household, a guest, or any other person under the resident's control shall not engage in criminal activity, including but not limited to violent criminal activity or drug-related criminal activity. And we're going to go ahead and outline what drug-related criminal activity means so that we're clear. That means the illegal manufacture, sale, distribution, use, possession, and that's with possession with intent to manufacture or sell or distribute a controlled substance. So we try to make that very clear in what our expectations are. The next thing is, not only do we not want you to participate in that kind of activity, but we don't want you to facilitate that activity. So resident, any member of the resident's household, guest, or other persons under the resident's control shall not engage in any act intended to facilitate criminal activity, including drug-related criminal activity on or anywhere around the premises of the household. And what you're saying is this home is not meant in any way for illegal activity. We say that in 3 by saying, resident or members of the household will not permit the dwelling unit to be used for or to facilitate any kind of criminal activity, including violent or drug-related criminal activity, regardless of whether the individual engaging in the activity is a member of the household or a guest. So the home itself in no way can be used for any kind of illegal activity. That includes, very specifically, because this does seem to be the largest problem that we face, this includes no drug activity. So in 4, we say, resident, any member of the resident's household, guests, or other persons under the resident's control shall not engage in the unlawful manufacturing, selling, using, storing, keeping, or giving. I don't care if you're sharing it or selling it. We don't want you to have any contact with a controlled substance, whether on or about the dwelling unit or the premises. So, not inside the unit, not on the porch, not on the deck, not in the yard, not in the driveway. Nowhere around that house will that be allowed. all illegal activity is to be banned. So we go back and in 5 restate some of this. We're going to say resident, any member of the resident's household or a guest or another person under the resident's control shall not engage in any illegal activity, including but not limited to, and here's where we outline some of the things that we have in mind, just to be clear: prostitution, criminal street gang activity, hate crimes, threatening or intimidating, assault, racial slurs, or the unlawful discharge of firearms on or about the dwelling unit premises, or any breach of the lease agreement that otherwise jeopardizes the health, safety, or welfare of the landlord, his agent, other tenant, or other members of the community, or involving imminent serious property damage, or that interferes with the right to peaceful enjoyment of the premises by other tenants or other members of the community. So here's the deal. No illegal activity. Not just what we've outlined here that covers generally the most common things that happen on the property, but anything else that I think might jeopardize the health, safety, or welfare of myself, my staff, other tenants if it's a duplex or higher, or neighbors in that community. And not just that if it jeopardizes them, but if it interferes with their peaceful enjoyment of their own home and their own area there in the community. So we're very clear on expectations of what we believe is a banned activity. Now in 6, we talk about what the consequences are. We say that a violation basically means you're out of there. It's no point for discussion. So this is very strong language in 6. We say in bold and caps, violation of the above provisions shall be a material and irreparable violation of the lease and good cause for termination of tenancy. So in other words, it's immediate. It's a one strike and you're out. A single violation of any provisions of this added addendum shall be deemed a serious material and irreparable violation and non-compliance of the lease, regardless of whether or not resident has any knowledge of the violation by an occupant, guest, or invitee, and regardless whether it's on or about the property. It is understood that a single violation shall be good cause for termination of the lease as set forth in the lease and here's this is in a Word document, so you need to research your landlord-tenant law, and if there is a statute there that talks about an expedited eviction, you need to put in that clause number or that statute number here in the fill in the blank. But what you're telling them in this, unless the law in your state requires that there's proof of this violation or that there's a criminal conviction, we're going to assume that just a preponderance of the evidence means we can go forward with this eviction. So if we have any kind of evidence that proves that you have been dealing in illegal activity, whether it's you, Mr. Resident, one of your household members, a guest, somebody you've invited over, somebody that stumbled onto the property and you said could stay a while. It doesn't matter. It doesn't matter if it's inside the property, if it's outside the property, doesn't matter. One violation and we will move forward with an eviction. We also let them know that we are going to cooperate in every way possible with law enforcement on this illegal activity. So in number 7, we say the residents, occupants, and their guests and invitees agree and understand that management cooperates with law enforcement agencies by allowing management to release any information that's contained in management's file regarding residents, occupants to any law enforcement agency upon request. The resident agrees that the landlord manager may use any police report generated as direct evidence without obligation in any court action, including but not limited to an eviction. So if we end up in eviction court, any police document, any police report that we have is going with us into that courtroom. And on the other side of that coin, if the police come to us in an investigation and say, what do you know about this person, any information that we have in our file as it relates to you, Mr. Resident, will be turned over to them. And then in 8, just to be clear, we say, in case of a conflict between the provisions of this addendum and any other provisions of the lease, the provisions of this addendum shall govern. Now, the reason that we did this is we don't know here at Arpola exactly what lease you're using. We don't know if you're a member and have used a lease that we have provided through U.S. legal forms, or if you have had your attorney draft one. So we don't know exactly what the clauses of your lease say. But we feel so strongly about this particular addendum, we believe that this addendum should be the reference point if there is a question about a legal activity as it concerns your resident. So that's what our clause here in 8 is used for. We also want to make sure that you use this document both if a lease is executed or if it is renewed. So each and every time they come in to sign a new lease, you need to get this addendum signed as well. So make sure it's dated. Make sure all residents that are on the lease also sign this particular document, and have the document signed each renewal time. Make sure you have a copy in your files, and that is available. It'll be terrific for you to have if you end up in eviction court, and it sends a very strong statement at the outset about how strongly you feel about keeping illegal activity out of your rental property.